So the Supreme Court stepped in early once again and issued a 6-3 order in a case dealing with the battle between Texas and the Biden administration over the border. So we need to talk about what happened in that order and then now what has happened as a result. Now, real quick before we jump into this video, I want to mention once again that we now have a podcast available. It's called The Liberty Lounge. It's myself, Jared from Guns and Gadgets, and then also Johnny B. We do a podcast every single week. It's releasing Tuesday mornings. It's here on YouTube. It's on all audio platforms. We would love your guys' support. So if you want to listen to some of that, we've done a bunch of interviews and some amazing interviews coming up. And then we just talk about some general topics as well. I will leave a link to all that down below if you want to follow. As I mentioned in the intro, we need to talk about how the Supreme Court just issued a 6-3 order in the SB4 case, which deals with the whole Texas border dispute. You may recall that recently in a different case called the Department of Homeland Security versus the state of Texas, the Supreme Court stepped in early and issued a 5-4 emergency order, which removed a Fifth Circuit stay. That prior Fifth Circuit stay essentially prevented the Biden administration from cutting wire in a specific area in the Texas border. As a result of that Supreme Court order, that set up a significant clash between the state of Texas and then also the Biden administration. And now things are getting even more hectic with a new Supreme Court order that was 6-3 in favor of the state of Texas. So the Supreme Court kind of did a 180. Originally in the first case sided with the Biden administration, and then now in this order, in this case, sided with the state of Texas. The Supreme Court just denied the Biden administration's request to vacate a Fifth Circuit administrative stay. The fact that this was a denial of vacating an administrative stay is going to be important to understand what this order really did. The Fifth Circuit administrative stay allows the state of Texas to enforce their new SB4 law while the Texas border case is being appealed in the Fifth Circuit and while it was moving towards a final decision. And one of the very interesting things with what is now developed after that Supreme Court 6-3 order is the fact that the Fifth Circuit has responded and kind of made this whole issue of the 6-3 order null and void. Now we need to talk about some background in these cases so you understand what the Supreme Court is dealing with and what happened in these two cases and these two orders by the Supreme Court. The first Supreme Court order involved overruling a preliminary injunction that was granted by the Fifth Circuit 3-judge panel. The Fifth Circuit 3-judge panel's decision essentially prevented the United States Border Patrol from cutting, destroying, or otherwise interfering with concertina wire or C-wire that the state of Texas had put in place in specific areas. In this case, the state of Texas was the one who actually filed the lawsuit against the Biden administration, against the federal government, claiming that there was a trespass on specific areas and that there were also violations of the Administrative Procedures Act, also known as the APA. In that case, the district court denied the preliminary injunction that was requested by Texas. So they denied what Texas wanted. Texas then quickly appealed that denial up to the Fifth Circuit Court of Appeals. And along with that appeal request, the state of Texas sought an administrative stay of the lower court's decision pending the appeal in the Fifth Circuit. What is important about an administrative stay is it's not actually even a true stay. An administrative stay is something a court can do administratively to maintain the status quo and give themselves, temporary amounts of time, just a little bit of time, so that they can actually review and decide on a true stay. So don't think of administrative stay really as a true stay. It is kind of this administrative process that courts do to buy themselves some time so that they can actually review an issue. The Fifth Circuit ultimately granted the administrative stay, which put the lower court's decision on a temporary hold. Now, as I stated, the federal government then sought an emergency application up to the United States Supreme Court. They asked for the Supreme Court to step in early and vacate the Fifth Circuit stay. And on review, the Supreme Court issued a 5-4 order, which granted the government's request to vacate that preliminary injunction and vacate the stay that was in place. That means that ultimately the Supreme Court voted in favor of removing that administrative stay, the temporary injunction that came along with that the Fifth Circuit had put in place. And the two judges who essentially jumped the line in that first case were Justices Barrett and then also Chief Justice Roberts. Now, while that first legal battle was happening, there were other cases making their way through the Fifth Circuit challenging Texas's SB4 and also its enforcement. Texas SB4 is different from the other issue, but SB4 effectively makes it a crime for an individual to violate federal law by crossing into Texas at any location other than any lawful point of entry. It also makes it a further crime to illegally re-enter after a person has already been denied admission into the US or has been previously removed from the US. And finally, SB4 makes a law where essentially judges can issue orders requiring these individuals who illegally crossed into the US to have to return to the foreign nation where they entered in. Now, this bill, SB4, was challenged by the Biden administration, and it went again to a federal district court, and a federal district court on review issued a preliminary injunction, which in effect prevents Texas from enforcing various parts of SB 4. Texas then appealed that injunction up to the Fifth Circuit once again. In response, the Fifth Circuit issued an administrative stay on the lower court's order, which in effect would still allow SB 4 to remain in effect while the appeal is taking place, and at least until the Fifth Circuit could actually review and decide on a true stay order. Various cases were consolidated then in this case, and then ultimately there was an emergency application that went up to the United States Supreme Court, and they were requesting that the Supreme Court issue some sort of emergency intervention and get rid of that administrative stay. If the Supreme Court granted the request to vacate the administrative stay, well then the lower courts, the district court's preliminary injunction, would go into effect and effectively block SB 4. So that's kind of what was at stake, whether SB 4 could or could not be enforced while the Fifth Circuit appeal is happening and while they were reviewing whether or not to grant a true stay. And then on Tuesday, we received a 6-3 order from the United States Supreme Court, which denied the Biden administration's request to vacate that Fifth Circuit administrative stay. That means that the Supreme Court decided in favor of leaving that administrative stay in place until at least the Fifth Circuit could either decide on a true stay order or at least until they decided the case. Justice Barrett and Kavanaugh concurred in the order, and they stated in their concurrence that if the Fifth Circuit had issued a stay pending appeal, this court would apply the 4-factor test to decide whether to vacate it. But the Fifth Circuit has not entered a stay pending appeal. Instead, in an exercise of its docket management authority, it issued a temporary administrative stay and deferred the stay motion to a merits panel, which is considering it in conjunction with the Texas challenge to the district court's injunction of SB 4. Thus, the Fifth Circuit has not yet rendered a decision on whether a stay pending appeal is warranted. That puts this case in a very unusual procedural posture. So she then goes on to state that administrative stays do not typically reflect the court's consideration of the merits of the stay application. Rather, they freeze legal proceedings until the court can rule on a party's request for expedited relief. She then goes on to state that, so far as I know, this court has never reviewed the decision of a court of appeals to enter or not enter an administrative stay. I would not get into this business. When entered, an administrative stay is supposed to be a short-lived prelude to the main event, a ruling on the motion for a stay pending appeal. I think it unwise to invite emergency litigation in this court about whether a court of appeals abused its discretion at this preliminary step. And then she concludes by saying that if a decision does not issue soon, the applicant may return to this court. So what does this all amount to? Well, this all amounts to the Supreme Court telling the Biden administration that its request for an intervention is essentially too early. They are asking for early intervention in this case, and simply this is an administrative stay. They're saying this is just buying the Fifth Circuit some time to review this issue. Give them time, let them review the stay order request, let them decide on a true state order, and then, if they don't do that, which they already have held a hearing on this issue, if they don't do that, well, then you can come back to us. But really, the Supreme Court order amounts to them just calling a false start on the Biden administration. It's just saying, hey, you jumped the gun a little bit too early. This is still making its way through the process. Let the Fifth Circuit Court of Appeals do their job. Now, something even more interesting and something that people are just simply not covering is the fact that in response to that Supreme Court 6-3 order, that same day, the Fifth Circuit Court of Appeals then issued its own order and they removed their own administrative stay. That Fifth Circuit order essentially states that oral argument is scheduled on March 20th, 2024 to consider the appellant's motion to stay pending injunction pending appeal. A majority of the panel has concluded that the administrative stay entered by a motions panel on March 2nd, 2024 should be lifted. So the Fifth Circuit merits panel and that administrative stay that the motions panel put in place, and that was debated in the Supreme Court and resulted in the 6-3 order and had a lot of people talking. Well, ultimately, after the Supreme Court issued that 6-3 order, that same day, the Fifth Circuit merits panel then removed that order. A hearing took place on Wednesday on a true stay order request, and then now we're going to be waiting to see what the Fifth Circuit merits panel decides as far as issuing a true stay. But for now, this is a kind of a merry-go-round with SB 4 and its enforcement. Even after that Supreme Court 6-3 order that happened on Tuesday, that same day, the Fifth Circuit removed their own administrative stay. So yes, Supreme Court said, we're going to leave it in place, but that same day, the Fifth Circuit then just removed it on their own. There was one dissent from one of the judges who said he didn't agree. He thought that they should have kept the administrative stay in place, at least until after the hearing, at least until after they rule on that decision. but he was overridden in a 2-1 vote, I believe. He was overridden, and so that administrative stay was removed. So SB4 still cannot be enforced because that preliminary injunction is in place. Hopefully you guys found this video helpful. I know this is a lot of information you're probably not getting out there. I know a lot of people just jump on the whole Supreme Court 6-3 order, but they're not giving you the nuance about what has happened after and what the Fifth Circuit did and the implications of truly what the Supreme Court said in that order. If you guys like this information, if you found it helpful, please spread it around. Make sure you're liking, commenting, and subscribing to this channel. As always, thank you all so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.